One of the most difficult constitutional questions concerns the ethical responsibilities of judges who believe they may no longer be capable of exercising completely independent judgment. The American legal system already recognizes circumstances requiring judicial recusal. Judges routinely step aside when financial conflicts exist, when close personal relationships create potential bias, when previous involvement in litigation raises concerns regarding impartiality. These standards exist because justices must not only be fair, they must appear fair. Public confidence depends upon both actual impartiality and the appearance of impartiality. This raises an important hypothetical question. Suppose a judge genuinely concluded that extraordinary external pressure had become so overwhelming that maintaining complete independence was no longer possible. What ethical obligation would follow? There is no simple constitutional answer. Many would argue that a judge's duty is to continue serving despite enormous pressure. History contains numerous examples of courageous judges who issued unpopular decisions while facing public criticism, political hostility, and even personal danger. Their perseverance strengthened judicial independence. Others might argue that if a judge sincerely believed fear had impaired objective judgment, continuing to participate in cases could ultimately cause greater institutional harm than temporarily stepping aside. The central issue is not weakness, it is integrity. Every judge takes an oath to support and defend the Constitution. That oath requires faithful application of the law, independent of personal preference or external influence. If a judge honestly concluded that independent judgment had become impossible, constitutional ethics would require confronting that reality honestly. Importantly, however, this hypothetical should never be misunderstood. There is no public evidence that any Supreme Court justice has reached such a conclusion, nor is there evidence that any justice has allowed intimidation to influence constitutional interpretation. The broader lesson instead concerns institutional preparedness. America should strive to ensure judges never confront such circumstances. Rather than expecting extraordinary personal sacrifice indefinitely, constitutional government should provide sufficient institutional support that judges remain free to perform their responsibilities without fear. The burden of protecting judicial independence belongs not only to judges, it belongs to the nation.